So you people should mark, I wrote this. So people got it right. So this one, let's pronounce it together. Eze versus what? If it is in my body, which law we apply? If it is in River State, which law we apply? If it is Adawara, which law we apply? Terrorism doesn't mean terrorism. If I stay here and say, if anybody not come out, I will kill that person, I will make sure I burn down this building, I will tell, that is amount to terrorism. Because we're already inciting violence. Okay, yo, I want to hear everybody's. What is not written there? What is not written? What is not written? Can you guys? Good morning, class. Hope you are ready, right? My name is Kingsley Ifeanyi Chukwu Omeyin, better known as King's Advocate, the law. So I'm happy to be with you all today. The first thing I wish to tell you people is that if you are judging your exam based on the way the lecturer is going to teach you in this course, after this tutorial, after this section, just have a rating. If you are judging your exam based on the way the lecturer is teaching you currently, after this tutorial, have a rating. And there is reason for saying that. And in the course of this discussion, we shall analyze some of those things. So basically, on today's tutorial, it's going to be categorized into 5 stages. The first stage, we are going to understand the meaning of legal method. That is very, very peripheral and necessary. That will begin with the meaning of legal method. Then on the second stage, we are going to discuss authorities. How to cite authority. For them that follow me on my Law Made Simple channel, I think we won't discuss it online, right? Yes. We shall just add a flesh to it. I think if majority are there, I will really be grateful because I won't have to go detail again, but we just have to touch it so that when we proceed to definitions of law and some other things, we'll be able to go. Then on that also, we should also discuss, that is the third stage, the full meaning of law. Then we understand how we are going to approach it. Remember, this thing is tutorial. So I'm going to try as much as possible to cover that area the lecturer will not be touching in the class. Then we'll talk about, on the first stage, we are going to talk about, delve deeper into the course outline in legal method, some certain things which I know that will be helpful to you people. So we are going to cover that. Then on the last stage, which shall be the 5th stage, then you will have the permission to officially ask your question. However, that does not mean that you cannot ask questions, because I understand if I am be talking now, there will be a time you will have to ask some certain things in order to flow. So you are free to do that. But the last stage actually is where we are going to then. You're going to have that privilege of asking any question, whether related to what I'm saying or different from what I'm saying. Now, we begin with legal method. So when we talk about legal method, what basically comes to your mind as a law student now? And just like I said, while talking to you people about our beginning here, that if you are judging the way you are going to write your exam based on the way the lecturer is teaching, you are going to make a mistake. Because most of these things, I keep saying it, no law lecturer is going to tell you define legal method. No law lecturer is going to tell you define law. So it's something which I think we are still early enough. Before we complete our exam, we are going to touch past questions in real time. So I will then tell you people that in as much as we are treating legal method now, just know it that you are not going to see anything defining legal method or unless the lecturer wants to do for that Christmas for you. But thank God we are not writing it in Christmas. That should be March. So you are going to be expecting something that is indirect. But then as a legal method law student, if questions comes before you, your ability, what will differentiate you in making A and other people who will be making B. B is even a good grade, who will be making F and all those things, is ability to understand the question, number one. And then your ability to connect so many things in that are not being directly asked. Now, I'll give you, for instance, if the lecturer is talking about law, let me just put something like this. Legal method is a course that is offered by any first-year law student. So far, the purpose of legal method has been to intimate potential lawyers on the understanding of law. As a law student, appraise this statement. As a law student, do you agree with this? As a law student, analyze on this. As a law student, what do you think on this? So something like this. Then, in such a situation, this is just one example. In such a situation like this, you are then expected to talk everything you know about legal method and then connect it with knowledge of law. So that's why it is important, in as much as it may seem simple to start with beginning of legal method and the meaning, you have to know it. If possible, you cram a particular definition you can remember. So we then begin with legal method. So the word legal method has two words on it, which is what? Legal and what? Now, method, we begin with method. Method, according to Oxford Learner Dictionary, simply means a systematic way of doing something or making something in an orderly manner. So when you talk about method, you are basically referring to a systematic mode or a systematic ways of doing something in an orderly manner. Then the word legal, all of us here, on our normal understanding, we all know what the meaning of legal, anything that relates to law, right? So legal means anything that pertains to law or anything that relates to law. Then when you join these two words, you'll be having something like legal method being something that will teach you the art of thinking like a lawyer, reasoning like a lawyer, behaving like a lawyer, and then being able to solve some certain legal issues or legal questions. Are we following? So when you connect these two words now together, the whole understanding should be that the legal method will teach you how to understand the law. Legal method will teach you how to apply the law. Legal method will first of all intimate you with the basic understanding of the meaning of law and so many things that are related to it. Through this course, that will then lead you to another thing you have to know about the functions of legal method or why we study legal method. So when you are answering the questions, anything that relates to law like this or anything that is general, basically we shall be treating this in past questions so we can actually relate to what I'm saying. When you are faced with that problem, what you will first of all do is you start first of all with letting the lecturer know what legal method is all about. And in law, there is no need to cram anything except if you want to quote it verbatim. That is when we shall be discussing definition of law now. That is when I will go detail about this. So it depends on your understanding. Like I keep saying, even in that group, I told you people that no lecturer that is setting any question for you, he has nothing in mind to expect from you, especially when law student is concerned. All he wants from you is your understanding. That's why many people will write different things, many people will write different things, but at the end, you see people getting A, you see people getting, these are one questions. But what the lecturer will check, as far as Professor Bag is concerned, is effort you are making to say something that he least expected. Are you people following? So that is one thing, like I always capitalize on. I will make sure that when I'm making my notes, I will add anything that will appease my lecturer, because these are the people that will mark you. And when they are doing all this, and they have many scripts. So if you can begin very well in a catchy manner, For instance, let me just assume that I'm attempting anything that has to do with legal method. I can possibly begin by, as a law student, one of the core course every law student should offer is legal method. Then it becomes necessary, before diving into this question before me, to even ascertain what legal method is all about. Legal method is a word that is made up of two words. One legal, and the other one is method. Legal has been defined as anything pertaining to law or connecting to law. Therefore, when we juxtapose it with legal method, we then have anything that intimates us, the newly admitted law student, on the understanding of the rudiment of the law. If you look at this thing now, any lecturer that read this thing for me will basically understand that I'm natural, right? There is no need of cramming, there is no need of all these things. By so doing, you will then have first impression before the lecturer. So these are just the secret of making A. And I know when this lecturer will be teaching you, I doubt if he's not reading from the textbook. He's reading from textbook, right? So most of these things, he will not, if you are looking at the way you'll be teaching, you feel like there is nothing here, or you feel like, what am I even expected to do? But this thing I'm telling you is basically what he wants you to do. Now is the opportunity to make this implement. So after this today, please take necessary of this thing. I have told you people, there is nothing like definition of legal method directly in quotes, but your ability to connect it will really matter a lot. Now, to define legal method, or if you are dealing with anything with legal method, you have to connect it with what? Law, right? You have to connect it with law. Now, assuming we are approaching legal method, like I said, everything that will come there is about lifting a statement, a lecturer making a bold statement, and then expecting you to either agree or disagree with that statement. So if you are agreeing, or if you are underscoring the point that legal method is very crucial in the minds of law students, especially for beginner, then after defining legal method, you then proceed to connect it to how it relates to law. And I will not go there now, because of that second stage we have to talk about authority, so that when I begin to give you people authority in definition of law, you people can relate. Now let's talk about authority before we then move forward to juxtapose definition of law with legal method. When you talk about authority, first of all, can anybody here just briefly, what is an authority in your own minds? If you can, quickly, we don't have time. Anybody? So let's not waste time. When you talk about authority, authority refers to any assertion, claims, or presupposition one asserts or lay that can be verified by anybody who wished to inquire the truth or the falsity of that statement. Let me just take it again. Authority refers to any statement, claim, or assertion that can be verified by anybody who wishes to underscore the truth or the falsity of such claims. You can actually put it in your own words, because I didn't cram it. I'm just trying to make a point. Now, reducing this definition for our own understanding, when we talk about authority as a law student, the question before us is, if I'm making a claim, what have supported this claim I'm making? The general principles of law, or the general principles of us as law students, is that you don't say anything without supporting it with what? Proof. Section 131 of the Evidence Act stated it unequivocally. This is authority you can still use. So you can write it down, connect it when you will be answering any question that relate to what? Proof. In fact, every question you'll be answering have everything to do with this section I pointed at. Section 131 of Evidence Act said, whoever is coming before the court and asking the court to do any favor or to rule on his behalf must adduce, that is, must bring evidence before the court to show that such fact is proven before the court exists. What do I mean? If you are going before the court, hello? Okay, I say that section 131 of the Evidence Act provides that whoever that is going before the court of law to lay hands or to claim on a particular thing must adduce evidence before the court to show that such fact he or she is claiming exists. You can actually put it in your own word that he who asserts must prove. Are we following? Section 131 provides that he who asserts must do what? That is just the summarized definition of it. Now, if you are going before the court, that is the general presupposition that you must prove something before the court. So it then lays on you as a person who is bringing a case to support it with authority. If I claim that Kingsley have killed somebody here, I must provide evidence that must show that I actually killed somebody. It's not just enough for you to go to the court and say that somebody has killed somebody. Please, you people should pay attention now, so we'll get it correct and flow. So that when I begin to talk about if you do this site authority, you'll be able to understand very, very well. Then if you are confused, you can always ask questions. So I talk about authority, and I define authority to mean any claim or assertion that can be verified by any person who is willing to ascertain the truth. Then I told you people that if you are going before the court, evidence law, which is the thing that guides everything you do in court, by virtue of section 131 says that you must what? Bring evidence to support what you are claiming. Then evidence can be in 2 points or in 2 types. I am saying this for a purpose so you people understand. It could be evidence of fact or evidence of law. Evidence of fact means, what is your name? Kamsi. Evidence of fact means that if something happened here and Kamsi died, sorry, you will not die. But if something happened here and Kamsi died, and anybody who is here, we then went to court and being prosecuted by the state. I will still talk more about how that one work. And being prosecuted by the state. The state, that is the state, the police and everything, they must show evidence. Number 1, under section 316 of the criminal code, which governs murder, that Kamsi is dead first. So if Kamsi is not dead, the question of whether I killed Kamsi, will it arise? So this one now is a question of what? Facts. That's why I'm telling you people, this one has nothing to do with law, right? The issue before the court is whether I killed Kamsi. So can you go to the court and be telling them Kingsley killed Kamsi when Kamsi is alive in the hospital? Is it possible? So that is one thing. Evidence of fact the state must bring is that Kamsi is dead. So many other evidence which I will not like because we are not in criminal law class. That is just one. That one is evidence of what? Fact. Then evidence of authority or evidence of law is the one that concerns us here because we are law students. We want to cite authority. Now, if the prosecution has proved that Kamsi is dead, the next thing is to provide law that stated what should happen to me for the fact that Kamsi is dead. They have to first of all prove that I'm the person that killed Kamsi. They must prove it. And then the presupposition of the law according to section 36 sub 5 is that every person is presumed innocent until when proven what? Guilty. So the law is on my side basically that I didn't kill Kamsi until they prove what? Prove me guilty. So are you people following? Yes. Now, to prove me guilty, what would they bring before the court? Evidence. Then another name for evidence as regard to this one I'm talking is what? Authority. I hope we are now following. So we have understand the one of fact, right? The one of fact is as simple as anything. Just show that Kamsi is dead, bring a medical report, bring this one, you are good to go. Then you then come to the another one, which is what? Law. So it is on this law that we as a law student, we are being trained now to cite authority. In other words, gone are the days when you will come as they tell you define law. You say, well, law is a body of, that one is even good. I think law can be defined as a body of rules and regulation which governs human conduct. You are done. Hoping to get A or hoping to pass very well. You think. So I have told you people right now, anything think, you should delete it on your wall. Even if there is no need to use it as a law student, you don't think. You can submit. I submit. That is when you have elaborated all that thing. Now, let's come back to what we are treating, authority. So, the prosecution, do we know the prosecution? When we say prosecution, do you know what it entails? No. We have a lot too. The prosecution, if it is a criminal matter, do you people understand? We have criminal matter and civil matter. We shall also come to that with time. When we talk about criminal matters, the rule in criminal matter is that it is the state that prosecutes. State here doesn't mean Enugu state. I hope when we mean state in law, you know what it means. Yes. A country, a nation. So that is what we mean in state in law. So the rule is that you cannot institute an action as an individual in criminal matter, except if you obtain a fiat from the Attorney General of the state or that of the federation. But it is rare. I have not seen a case where an individual obtained a fiat from the Attorney General to prosecute. Meaning that if I kill your brother, you will be permitting me to be using this word so it will be clear. So if I kill your brother, you cannot, because he's your brother, to take action against me. The least you can do is to do what? To report to the police. Then the police will then take the action to prosecute me. Are you people getting the point? But on the other hand, if I take your land, if I take your book, if I take your bag, if I take anything, you can maintain action against me because it's what? Civil matter. I hope you understand now. So we are now talking about the prosecution. The prosecution are the people now, the police or the states or the FCC or just any agency of the government. They are doing it on the behalf of the government. And now, let me just make this point. The rationale for individual not prosecuting in criminal matter is because a crime is against the state, not against you. If I kill somebody here, I committed crime not against you. I committed the crime against the what? The society. So because the crime is against the society, it is the society that have right to do what? Prosecute me. So that one has settled it. Now, if the prosecution have proved the fact that Kamsi is dead, the next thing they are going to then do is to bring up law authority. Because section 36 sub 5 is in my favor that I am innocent, even though my hand is in blood, I am presumed what? Innocent, until they prove me what? Guilty. Because of that, the burden of proof then moved to the prosecution under section 131 of Evidence Act again. So if now the burden is on them, the only thing they can use to convict me is what? Authority. Are we people getting the point? So authority is then what they are going to use to bring me down, to convict me. So now that is the need why we talk about authority. I believe by this point I have laid that foundation on what authority means. So the next thing we are now going to do is, what are the types of authority? Then after I will tell you people, how can I cite it, and where will I cite it, and why is it necessary? Types of authority can be categorized in two forms: primary authority and secondary authority. Take this thing I'm saying as important as, because there is no course outline that talks about authority. But the reason why I'm just going this way is for you people to understand, so that when I begin to say according to this person, you will actually know that we are in the same page together. So there is no topic about authority. Now, authority could be primary or secondary. Primary authority refers to those authorities that are strictly binding on the court, and they have no discretion as to apply it or not apply it. I will repeat again. Primary authority refers to those authorities that are binding on the court, and they have no discretion as to apply it or not to apply it. In other words, when you talk about primary authority, it is that one that mandates the court to apply it, whether they like it or not. Because we are law students, we are here to get to the court, we must approach it in academic perspective. So when I talk about authority in this sense of being a law student, I refer to that thing or that claim that you have to use to support whatever argument you are making to your lecturer. It could be in meeting, it could be in your exam, it could be in any other exercise. That is what authority means in this sense of primary authority. Do you people now understand what is primary authority? So if I cite a primary authority before the court, there is no discretion as per I will choose it, I will not to choose it. And I will still tell you people how authority can govern the court. Now, what are the examples of primary authority? Number one example of primary authority is what? Statutory authority. Statutory authority. I mean, get it clear. We say that authority could be what? Primary or secondary, right? And then under primary, I'm trying to tell you, give you people the one that can be classified under primary. We have number one as what? Statutory authority. Then we have also number two as what? Customary law. Statutory authority, customary law. Then we also have what? Judicial authorities, or case laws, or judicial precedents. These are what? Types of primary authority. Now let's talk about the statutory authority. According to section 36, if you are diligent enough, you can copy, just be noting down only this section I'm citing. Every section, every case, every this I will be mentioning here has everything to do with what? The authority you use in your legal method. So I'm not trying to, I will not go extra mile to other law evidence. I'll just tell you the one that relates to you. So when we talk about statutory authority, under section 36 sub 12 of the 1999 Constitution, section 36 sub 12, do you even know how to pronounce? I say you should give me a marker. Are you with it? So under section 36 sub 12 of the 1999 Constitution, the position of the law is that no person can be convicted on any crime that is not written down, or that is not defined, or that is not clearly stated. So any crime that is happening in this life, once it is not written down, you cannot be what? Prosecuted. You cannot be convicted. You cannot be taken to court. Then the case to support this assertion is case of what? Awuko and Fagbemi. Awuko and Fagbemi. A-O-K-E. Sorry, A-O-K-O. Awuko and Fagbemi. That thing will not clean you. So let me just, don't worry, let me just show you people something. I will not write much. So now, this is what I wrote. You should not mind any other thing here. Are you people looking at this? So how to cite this thing for them that know? If you don't know, just listen again. How to cite, if anytime you see this thing, this one imply section 36 sub 1. What? Section 36 sub 1 what? As amended. Who said that? You are correct. Because you met me in Hosi one day. Okay, section 36 sub 1 paragraph A. Then if there is another thing here, like 1, this thing are in our laws. Do you understand? So anytime you see it, this one means section 36 sub 1 paragraph A I or A1 or whatever. But this one, you are referring to this one as the main section. This one is then, as you pronounce it, you mean subsection 1. This one you call it what? Paragraph A. Then if this thing is under pronunciation, are you getting the point? Or if it is in writing, you just put it here. So you'll not be talking about section 36 like you'll be writing it verbatim. Do you understand? So this one is just in word. That is how you pronounce it in word. And now let me just show you people something. This board is not clear at all. Let's look at this one. Can you people see it? You can't see it. So you people should mark. I wrote this. Let me write another one here. Eze again. Kingsley. So people got it right. So this one, so let's pronounce it together. Eze versus what? This one is what? Eze v. Kingsley. Okay. You again. See how it's done. That's why this tutorial is important. You will not learn this again. This one is what? Which type of matter is this? What type of matter is this? So this one is criminal matter. This one is civil matter. If this one is criminal matter, how you pronounce it is Eze against the state. Do you understand? In pronunciation, the correct pronunciation is not Eze versus the state, not Baka versus who are the footballer here? Man U. So you just say Eze against the what? This one is what? This one is now known as Eze and Kingsley. Eze and Kingsley. Let's get it correct. This one is, if it is criminal matter, I believe you people have understood why it is criminal matter now. So we then call it, if you are pronouncing it as a law student or as authority. I'm saying this one in case now you are making a presentation, because I believe if you are writing, it must be like this. But we are talking about making physical presentation. You don't come and say, I'm supporting this thing with the case of Eze vs. State or Eze v. State. You say Eze against the what? The state. Then for this one, you say pronunciation, you say Eze and what? Kingsley. Are you people getting the point? Eze and Kingsley. Eze and the state. That is how you what? You pronounce it alright. You can go.
So there are people using verse.
Is it in your words? Yes, there is no need. And possibly also in writing, there is no thing that supports using this. Adding S to it. It's just V. But in words, you pronounce it as Eze and Eze against the state. In civil matter, how you will know civil matter is that it must be a name to what? A name. This one, it can be this way, Eze and state. State and Eze. State, let me be using the correct word. Eze against state. State against Kingsley or state against Eze. It can also be FRN against Eze. You people know what it means? Of Nigeria. Like case of Nnamdi Kanu now is pronounced FRN against Nnamdi Kanu. It is what? It is coming from the federation. This one most often, there is no anything to tell you. This one most often is what? States. Then most often, if this case happened around 1960, if it's around 90, before 1960, when the Queen we are ruling us, have you people come across something like this? You people have not come across it. You people have not come across it. Let's forget it. so that I won't confuse you people. It's when you get to criminal law, you will be seeing R, Quen. Those ones are the ones that have been decided before the 1960 when we gain our full independence and then we become a sovereign state. But if you see FRM, it means Federal Republic of Nigeria. If you see this one, it means state. Then you pronounce it as Eze and state. Eze against state or Eze and king state. Do you people understand? So I believe now we have understood that one. Then I was trying to make a point about statutory authority. Then before I decided to show you people this, I was on section 36 subwords. So when the essence of saying this now is when I begin to say sub, you people will then know how it is pronounced in written. Now, statutory authority is that authority that has been written down in a particular document. Statutory authority is any authority that has been written down, codified, or encapsulated in a document. Statutory authority refers to any authority that has been written down, stated down, encapsulated, or codified in a document. I'm telling you people that if you are in criminal law, anything, or if you are talking about crime, if a lecturer says a question, problem question, and is talking about crime, just know that if there is nothing like a law that has been made as contained in that problem question, that person has violated. The issue of crime does not what? Arise, right? I'm saying it because the question is going to be coming in problem question. So if a lecturer put up a question, painted scenario, talk a lot of things, and then you are talking about it, for you to cite authority, it must be what? Statutory based authority, because there is no crime. You can't punish anybody for any crime that is not written down, right? So you people should know that statutory authority basically is those ones that have written down. That is what I want you to know. And then for the fact that something is written down does not ipso facto makes it a law. If now you talk about statutory authority, there are those ones that have been written down, that have been quantified. That is when you talk about section this. It could be constitution, it could be evidence act, it could be same-sex marriage act, it could be freedom of information act, and so many more acts are carrier. Do you people understand? There are many acts. As you go, you begin to see all of them. And now, because this thing is still elementary and necessary, let's understand. Do you people know what the meaning of acts? When we talk about acts and law, do you know what it means? Acts, law, bylaws. Any law, take note, any law that is made by the federal government is called acts. Acts, that is A-C-T. You can add S, as, if you're talking about more than one act. Now, any law that is made by the state is called laws. Just get it like this, then I will explain all of them. Any law that is made by the local government is called bylaws. Under Section 4 of the 1999 Constitution, the federal government, talking about the legislature, the Constitution, by virtue of Section 4 of the 1999 Constitution, empower the legislature to make law for the good governance of the Federal Republic of Nigeria. If you come down a bit to Section 4 of that 19, first of all, Section 4 is a part of the Constitution that empower the legislature to do what? To make law. Remember, the Constitution divides power in how many types of arm of government do we have? So I named them. Legislature, executive, and judicial, right? Section 4 is what created what? Section 5 of the Constitution created what? Section 6 of the Constitution created what? Thank you so much. We are under Section 4. Okay, what? Chapter. Okay. Chapter under did anybody come with Constitution? Can I say people should come? Hey, you can just hold it, just hold it. You read something for us as you progress. Chapter. If you go to the structure of the Constitution, chapter is like what house? Chapter is like this faculty, a building. It houses a particular thing that are related. Then if you talk about section, we begin to talk 500 level class, 100 level. Are you getting the point? Still under that section, you then begin to see what? Section this, sub, and all those things. So now, under chapter 2, let me just put it this way. Chapter 2 talk about the fundamental objectives. We will still come to that. Chapter 4 then talks about what? The rights, all the rights we have. And so many other. For now, these two chapters is what concerns us. And then preamble and the first beginning section 1 and all those things, they concern us mostly. So if you are talking about the legislature, any law that is made by the legislature in the federal government, that is Abuja, is called what? Act. Then for the states, they are known as what? Laws. And then that is where the confusion comes. For the fact that we say that state any law made by the state are known as laws, we use law as a general what? General name, general term. Thank you. So we use law as a general term. So when we say law, don't just assume because we say that any law made by the state is what law, that you assume that it is what made by the state. Are you getting the point? We just use law just like a law student. Everything that has to do with law is just housed by that name, law. But for law students, you should then know to what extent it applies. Do you people understand? So we have gotten that act is the one made by the National Assembly. Then, if we have gotten this aspect of statutory authority right, the next thing we are going to consider is what? The judicial authorities. Judicial authority then refers to this thing I have mentioned here. That is what we refer to as judicial authorities. You have to then know what makes them judicial and what makes them even binding in the first place. Remember I told you people that are primary, right? So that when you are citing it, when you are supporting it, when you are making either mooting, presenting something, answering your exam, you will then know that when you cite this, you know how it applies. Because at some point there, to counsel, they will present you with a problem question that has two cases. Then the other person, this one will come in second semester. The other counsel, they will use maybe one name, Chidima. Chidima cited this. The other person cited this. And they will then tell you as a law student. They will tell you as a law student, check the one that is binding on the court and the one that is not binding on the court. I will follow you. Most of you are drifting. You got my point, right? I said, I'm telling people to know the bindingness of either primary or statutory authority, because if you are faced with problem question tomorrow, they may present a case. Chidima is representing the prosecution, Ada is representing the what? The accused. And then the other person cited this, the other person cited it. Then Professor Babu could tell you, mostly in second semester, he will tell you to examine the one the court should follow. Do you understand? So you can only examine it by knowing which one is binding and which one is not binding. And we are talking about, we say that statutory authority is what? Which one are we going to now? Or are we talking about judicial rights? So what is judicial authority? Judicial authority basically refers to those judgments, those judgments. Judicial authority basically refers to those judgments, decisions, or verdicts of the court or tribunal, competent court or tribunal. Judicial authority basically refers to those judgments, decisions, or verdicts that has been given by competent court or tribunal. Competent court or tribunal, because not we have everything is not called. There are tribunals, but we shall not get there now. So when we talk about now judicial authority, what will give us the understanding of how judicial authority works is what we know as what? Judicial precedent. Have you ever heard of it? Yes. So judicial precedent simply means, it can be called stay decisis in Latin. Stay decisis means let the what? The decision stand. Stay decisis is another name for judicial precedent. They can be used with case law. You can either call it case law, judicial precedent, or stay decisis. They are all talking about the same thing. Nigeria, we got our everything we do here from the where? From the English, Britain, right? So the judicial precedent then means that if a matter, let's use Eze and state. If a matter is decided between Eze and state, and the reason for the decision, they just decided a matter in that particular Eze and state, and another case came before Kamsi and state, what the court will do is, if what happens in Eze and state is similar to what happened in Kingsley or Kamsi and the state, what the court decide here, they will apply it to my own case. Are you people confused? Okay, I'll still explain. The working of the judicial precedent is that there are hierarchy of courts. You people know there are types of courts. We have customary courts, we have magistrate courts, we have state high courts, we have federal high courts, we have court of appeal, and then we have what? The Supreme Court. Once they decide, now Father Abraham will talk about that one. So if you are talking about, let's begin with the highest, the apex, the Supreme Court. If the Supreme Court rule anything, if they decide anything, remember, let me make this point. There is nothing new in this earth. Everything we are doing is more of repetition. So in all cases you are taking before the court, it is very rare for you to say that what is happening in that your case have not happened before. Are we following? So we have a long way to go. The reason for judicial precedent originated from the common law. Do you people know what common law means? Common law is coming from the word, the English legal system. They started, the way you are looking like you are lost. Are you lost? So they started, I want to lay this history so that after today, you will now understand what judicial precedent means. In the olden days, during Roman Empire, that is when law originated from the Roman Empire. They started something that if a matter comes before them, they will decide a matter, they will write it down, they will document it. Then if another matter comes again, they will decide something, they will document it. So over time, they have pile up of decisions. Then what they do is that if you come before them, they will not go again to be, once you are presented, remember we talk about proving fact and what? Law, right? So once you have proven facts, like you say that Kamsi is dead, then they will look at another case they have decided before to check what happened in that case. If it has similar relationship with this one, they will then adopt their judgment and apply it in your own. Do you understand? So that means then that thing is now binding. So what we do now in Nigeria in this recent context now is that if Supreme Court gave a judgment, the Court of Appeal, which is closed, you saw how we highlighted it, right? We are starting from the top. If Supreme Court gave a judgment, the Court of Appeal must do what? Must apply it. They must follow it. So if, let me just use something that is very, very understanding. Let's take for instance, you people know what happened in 2023 general election, right? Case of our man Tinubu and P2B. In that case, you people saw the judgment they delivered. One of the judgments they delivered in that case was that Abuja is not a state. I know many people didn't care about the legal aspect of that case, right? So I will just use this thing to explain something. There is a constitutional provision that for you to win an election, you must have gotten some substantial amount of vote across the state. You people know. So it's not just, if now, let me say Lagos State have a good population that Lagos State can be equated with other states. Like if you place Lagos State here and place the entire other state, Lagos State is bigger. Even if Tinubu win there or P2B win there and he didn't win other states, for the fact that Lagos State vote exceed that of the whole Nigeria, he cannot be a president. Are you people aware? So what happened in that P2B and Tinubu case is that Tinubu didn't get a good vote in Abuja. So P2B was the counsel to P2B. They were arguing that since Tinubu didn't get a substantial vote in Abuja, the court should not give him that privilege because he didn't meet that constitutional requirement. So the court then ruled that Abuja first should not be treated as a state. And for the fact that you didn't get a good amount of votes in Abuja when you have gotten other states, doesn't make you non-winner. You people know, you people have seen what the court ruled, right? If, which I know 2027 is going to be another problem again. If, who is coming out now? If Tinubu, P2B again, because I know he's going to come out. Or let's say, if Tinubu and Atiku, then have another question like this. If Tinubu didn't win again or Atiku didn't win, if that matter comes up before, let me say 2028 after the election, what do you think will happen? They will just go and dig up by simply saying, I am ruling that Abuja is not a state, based on the Supreme Court decision in the case of what? P2B and what? You people now understand what we mean by this. So for you to apply for the lower court, when I'm talking about lower court, I'm talking about their hierarchy. For the Supreme Court judgment to be binding on lower court, the fact must be what? Similar. What is the fact first in the first place? What is fact? Fact simply means the surrounding circumstances in a case. Let me just assume you are going back to the hostel and see people fighting. The normal, apart from being a law student, if you are a reasonable human being, the first question you should ask is what? What is the problem, right? You saw them fighting, you saw them slapping each other, and you are still asking what is the problem. Is it that you can't see? No, you can see, but you want to know what is the reason for their fighting, right? It is that reason of their fighting is what we can regard as facts. So if they are fighting and you are a lawyer, you will just see either they are dragging something or they are not dragging something, whether they are fighting for boyfriend or girlfriend or they are not doing that. That is the fact. You cannot go and be talking about his mother didn't pay school fees before the court. What concern a mother paying school fees and fellow law student fighting? Does it connect? So facts are those ones that are relevant to what? Case. What we normally say, fact relevant in issue. This thing is very important in your exam. If they set a question now, they are going to say many things, especially from your second year, second semester, this 100 level. They are going to say so many things. What I do is that I will pick up my pen, I will be underlining it. If you are reading your question, the emphasis should be on something like names, dates. Date is very important. So those things you will be underlining it or underlining at the end. Then those things you underline is where there is a problem. Do you people understand? So those things you underline, facts, just know that fact is whatever that is the problem. But then fact, there are facts, there are types of fact, but what the court will decide is the one that are what? Relevant to the issue before the court. Do you people understand? So you cannot go to court, two people are fighting and you'll be laying emphasis on whether he ate this or did it. That things, it doesn't make sense. So those ones that make sense is what the court will decide. So I'm trying to tell you people that for the judgment, that is judicial authority, for the judicial authority to apply, or for the lower court to apply it, it must have what? Similar facts. And the similar fact in the example we gave is the issue of what? Abuja and vote, right? So any other matter that comes to Abuja and vote, the court must do what? Apply it or not apply it, depending on how closeness it is. This thing will lead me, when I'm talking to you people about, have you ever had something like overruling a case, reversing judgment? All those things, we shall still come to that when we'll be talking about this one. Now, the emphasis we are laying is on what? Authority. So as a law student, we are not in court yet. So what matters now, what matters most now is if you are citing this case you are citing must connect to the question the lecturer have asked you. How will you know that it connects to the question the lecturer have asked you? I'll give you an example. Territorial scope is one of what? When we say territorial, O30 law student. Territorial scope is one of what? Qualities or characteristics. People should be careful with that two things. If you miss it, the man is going to get you. I think that thing is 66 in number. If you miss it, the man is that where he failed most of us. If you miss that thing, you know, it's always, it can be confusing. You can carry one quality and even fool in characteristics. You can carry characteristics and go and fool in. So mark those things. He will ask you, you're going to see it. So characteristics of a good law is territorial scope. Now, this thing will help you to add authority when you will be writing that, because I know it's going to come out. So if you are talking about territorial scope, under our Nigerian system, this time I'm still talking about authority, but I want to make a point. Under our Nigerian system, two laws as far as crime is concerned, two laws is what governs us. We have penal code and what? Criminal code. If something happened in the southern part of the country, you are going to talk about what? Criminal code. If it happened in the northern part of the country, you are going to what? Talk about penal code. Now, if they present you with the fact that maybe Professor Bible said that Okeke is being charged for adultery in the northern part of the country, you know, they have seized his property. These are the facts, because they can't just come and tell you Okeke is being charged with adultery. What do you think? They can't do that. They will include many things on so date. They were this, they were that. As the police came, they arrested Okeke. Now they have come to you after you have had many things. They have come to you as a lawyer. Please advise Okeke on what he should do, or please as a counsel to the prosecution, advise the Attorney General on whether to maintain action or not. Now we check about issues. How will you get issues whether or not Okeke should be convicted for adultery? You can only get it by what I told you people underlining. That is getting what? Fact, right? You get the relevant fact. The relevant fact would be date. The relevant fact would be whether, you know, how did adultery happen? Where did it happen? Was it in Lokoja? If it is in Lokoja, which law will apply? Jesus. If it is in Lokoja, criminal code will apply. If it is in Makurdi, which law will apply? If it is in Rivers State, which law will apply? If it is in Adamawa, which law will apply? You see why this general knowledge as a law student is important. So as you can see now, for many people, they have presented with you facts. Now, as a law student, you then underline what matters. Where did it happen? You should know that even if they may not use the real states like Adamawa, they may use they will just maybe in Amedu this, Amedu that state. But the surrounding fact will tell you which part of the country. Are you getting the point? So if you have gotten the part that what this thing is we are talking about is what? Rivers State. Then which law apply? We said is what? And then you have gotten the fact whether or not Okeke should be convicted for adultery. You then start with what? Answering the question. To answer the question, you then have to apply rule. So rule is then what we call as what? Authority, right? Now let me tell you people something. You cannot go to this law question and be, like I said it before, you cannot just go and start saying Okeke should not be convicted. That's all. Or you start writing everything you know about adultery without stating authority. So that's why authority is important. Now, if you have gotten it, which case should apply? I want to give you people a case now. Awuko and Fagbemi. So that Awuko and Fagbemi becomes our what? Which types of authority? So that Awuko and Fagbemi has become our judicial authority. There are places you will not find statutory authority. There are places you will find both statutory authority and judicial authority. But for law students, you could cite, I will still come to how you are going to cite it, but you could cite each and every one of them depending on the fact. So like I told you people, for you to cite a case to support whatever you are writing, the fact must be what? The fact must be similar, right? They must relate. The same thing applies to statutory authority. They cannot be asking you about, let me say, Professor Bible painted a question. Somebody is convicted of a crime. And then, according to the fact, what you have written down in that problem question, there was no law written down when that person committed it. But because Okeke committed that crime today, tomorrow the legislature then made a law, then advise the parties on whether they should maintain action or advise the accused person. So in this case now, Prof is trying to test you, your understanding on what? Statutory authority. So you cannot answer this question and get a mark without pointing section 36 sub 12. Are you getting how it connects? So I'm trying to tell you that henceforth, whether in mooting, whether in your exam, you cannot write anything without having what? Authority. Once it is your authority, in fact, they will grade you more often in authority. That's why most of the times when I'm writing my own, I'll just be using red biro sometimes to cite authority, because if you make it, there is a way you'll be writing. That is what we give you a. You just have to be different in what you're doing. So if you cite it later, if the lecturer comes to it, the lecturer will see the authority you cited. He can just grade it without reading whatever, all the story you have told him. But if you end up saying story without citing authority, you are failing. So now, if you have gotten that, what happened in that Awuko vs. Fagbemi, first of all, that case is the first case that decided on the issue of adultery. Somebody was convicted in the southwest. Remember, southwest is under what? Southern Nigeria. And then that person was charged for adultery before the customary court. That is I'm trying to lay the fact of that case before the customary court. So the customary court then convicted the person for adultery. So the question before because the customer back then, that I said this thing is the first case that decided on adultery. Back then, the courts have not interrogated any issue about adultery and all those things, or they just convicted the person. Normally, customary courts, they can apply things based on morality. Because when we shall proceed now, you will just know that there is a huge difference between law and morality. Simply saying anybody that hear adultery based on biblical perspective will know that adultery is immoral, right? So the customary court just went ahead and convicted the person. Then when they get to the higher courts, now another court in hierarchy, so they raise issue whether or not the person can be convicted, number one, on a crime that is not written down. Remember, there is no law in southern part of the criminal code has been in Nigeria since the colonial masters. It has been long ago. What they do is repealing and amending. So there is no place in southern part of the country that talk about what? Adultery. The reason for that is that we, the southerners, when it has to do with women marrying more than one wife, we don't see it as evil. That would then, when we shall be talking about sociology of law and philosophy of law, that is when we shall also talk about this. So in the southern part of the country, we don't see anything bad in it. So they then brought that issue before the court. The higher court ruled that number one, nobody can be convicted for any crime that is not written down, based on section 36 of the Constitution. Two, adultery is a crime in the penal code. by virtue of section 387 and 388 of the penal code, adultery is a crime. But when you come to southern part of the country, there is no provision. Are you people understand the point? So the court then ruled that Aoko cannot be convicted for what? Adultery. Do you understand? So now, if Professor Obagu presents you with a question that has to do with this, which law will you apply as authority? Aoko versus Obagu, right? You can simply say, should I give example now? Okay, let us assume, like I said, the question will not come directly. It could be Okeke and Mboye has been doing their business. Then in the course of their business, it happens that, just understand my example, I will be just casual. In the course of their business, it happened that on one night, Mboye didn't return early. And then Okonkwo, the husband to Mboye, then went to knowing fully well of the business Mboye used to have with Okeke. Then he went there before God and man. He saw something that his eye cannot tell. Aggrieved, Okeke brought up his machete to take action. Then, on the second thought, he remembered that he has a law student named Ada. He then went back and asked you, what do you think I should do in this scenario? Should I take my machete and do the needful? Or what do you think should be available to me? Then, advise Okeke. A, advise Okeke. B, advise Mboye. Then C, advise the prosecution. You people see, this is just an example, right? Now, in this case now, you have seen the fact, not everything, but the fact they are doing business. Does it concern us here? What concerns us is what happened inside that building. What concerns us is whether Okonkwo and Boy are what? Husband and wife. What concerns us is whether the other man that is doing that thing, does he have any marital relationship? Because under customary law, you are free to marry like King Solomon. Does he have any other thing to do with that? If that, so these are the things. Now you raise your issues based on this. You can't come and just say, well, I advise who are we advising? Say, Okeke is the person that who brought machete, Okeke, right? You cannot be advising Okeke and just simply telling him that you should not maintain an action before the court, or you should maintain action before the court without giving Okeke where to base his argument. First of all, you are the person to take that matter to the court. And remember, when we are talking about court, we are law students. What concerns us is academics. What concerns us is academics. So I want us to put down court aside. What concerns us now is to answer that lecturer question. So you cannot just come and say everything you know about. If you are talking like that, you are talking like a market woman, you are talking like a priest, you are not talking as a law student. Because for those who are too moral, they can just agree that there is a crime without even checking where did this action of Okeke and Boye took place. Are you people getting the point? Yeah. So if you had took place in the northern part of the country, it's not the way you advise Okeke, it's how you advise him in what? This is law. This is not morality. So if you are being blindfolded by morality and being blindfolded by everything, you make a mistake. You check dates, you check place, you check parties, you check all those things. That is what is fact in issue, fact that is relevant. So this is what I have to say about judicial authority. Now, another thing you ought to know, yeah, you will encounter that one, the hierarchy and the bindness of all those things. You encounter that one. Then we talk about customary law. Customary law is authority, meaning that if a particular society has a way of doing their things, for instance, in a particular, under our customary law, an individual cannot sell or alienate the family property. You now in your family, no matter how strong you are, you cannot take the general land of your family to sell. Are you getting my point? Yes. That is the custom. No individual owns a land under our traditional society, except if you have purchased that land with your own money. But any family property as an individual, you have no right to sell it. So because it's not written down doesn't mean that it's not law. Are you getting the point? But if it has to be criminal matter, it must be what? It must be written down. But if that's why they say customary law doesn't apply in what? Criminal law. Know it today. You can save this one in your memory. Customary law doesn't apply in what? Criminal matters. So customary law is a standpoint of authority. Now, the rule again, the rule of law as decided in case of Okeje and Okeje is that for customary law to be binding, this one is very important because he has been asking this question every time about all this issue of customary law and customary law. So if you are talking about customary law, the rule. Remember, you people now know the authority I cited is what? Ukeja and Ukeja is what? Civil. Which authority? Which type of authority? Judicial authority. So as you see now, I said something, and then because I'm a law student, I backed it up with what? Authority, right? This is how you should be speaking henceforth. So the rule now is that for customary law to be binding, it must not be repugnant to natural justice. Number one. For customary law to be binding, it must not be repugnant to natural justice. For customary law to be binding on court, because I'm telling you this so you know how extent. If somebody cites customary law, you check what is in issue. If that thing is repugnant to natural justice, it will not apply. Repugnant to natural justice means that any law that denies women their further inheritance is what? Null and void. I hope you should know that by now. There is no tradition in Nigeria. All this Igbo tradition they are doing in Anambra and Enugu and all those things. Once it has been challenged, the problem is that we don't take things to court. If they deny you your father inheritance because you are a woman, if you go to court, the court will mesmerize that tradition. Because it is what? No, because it is what? Repugnant to what? Natural justice. So what I'm trying to tell you people that if you cite customary law, it is binding only if it is what? Not repugnant. That is only if it is not against natural what? Justice. Natural justice is that everybody is equal before the what? A woman is equal before the law. A man is equal before the law. So are you getting the point? So for you to, I'm trying to tell you the defect in customary law as an authority. So that if you hear any authority from the customary law, you check what is the issue. If it is something that is noble, like for the fact that land belongs to family, and any land that belongs to family or property that belongs to family, you have no right to sell it, except if you get the consent of the elders or the principal members of the family. So if you must sell your father's land as a, what do you call, last born, right? Last born, you must get the concept of the what? The elder and any other relevant person in the family. That is that one. So customary authority, just know that customary authority are what? Only binding if it is not repugnant to what? Natural justice. Secondly, if it is not inconsistent with the what? The Constitution. By virtue of section 1(1) of the Constitution is what? Supreme. And its provision shall be binding on all persons in the Federal Republic of what? Nigeria. So, if any customary law, remember customary law is different from the English law. Customary law is the one that is gotten from our what? Forefathers, right? When our forefathers made those laws, they haven't anticipated there is nothing that will be constitution, right? So, the court is now tell you that they will not do away with our father's custom because it is our tradition. But provided it is not what? Inconsistent with the what? One of the inconsistencies is that a woman should not do what? Is that consistent with the Constitution? So you have seen it. The Constitution states, by virtue of section 42, that there should be no what? Discrimination. On the basis of what? On the basis of what? Sex, gender, sex and places and all those, right? So if any customary law is saying that, okay, this thing could come as a problem question. Okay, is claiming that, okay, should I create another question again? Let me just assume now, somebody died, the father died, dying without a will, that is intestate.